now. Can you see remedies?
Boom. Yes, sir.
Okay, my apologies. Okay, this section describes how both parties agree to deal with breach of contract or any other disputes that may arise. It's important that these provisions are included in the rare event that things really go south. But in my experience, even when things don't go perfectly, everyone is usually willing to find a way to work it out so we can close the sale, which is really what everybody wants. I give the overview of what this section's all about, and I also try to manage their expectations and talk about the reality of things rather than the fact that the paragraphs that come after this are going to talk about really bad things happening. So the first section is 7A, cure period. For those of you that might be new, the top box is the actual language that we see in the contract. The bottom box are my words, the way I would describe what that paragraph means, which I'm going to read each time. If either party fails to comply with any part of this contract, the other party can issue them a notice giving them 3 days to comply. We call that a cure notice. If they fail to comply within those 3 days, they are in breach of contract. If we find ourselves in that situation where we think it's necessary to issue a cure notice, I will provide you the form and deliver it to the seller. Because some buyers might be saying, what the heck is a cure notice and how do I get that? So another way that I try to manage my buyers' expectations. And please feel free to jump in anytime with any questions, because this is going to go much faster than the first couple sections. Here's a great big paragraph here that I don't know that many of us at all, including myself, have ever really read it start to finish and tried to absorb it and comprehend it. I have only because I was preparing for this class. But this is how I explain this paragraph. In the event that one party is in breach of contract, the other party can cancel and even proceed against them with a claim or remedy. If the buyer is in breach, the seller has the option to just accept the earnest money as damages, which is typically what happens. However, if the buyer is in breach because their lender failed to deliver loan documents on time, or they could not get the loan because they waived the appraisal contingency, the seller is limited to only the earnest money as damages. I'll bet a lot of us that are even more experienced didn't know that that limitation was there. That if the buyer is in breach because their lender failed them and they didn't get the loan documents on time, that is a breach by the buyer, but the seller cannot sue them or make a claim beyond the earnest money if that was the cause. Or at least that's what the seller is agreeing to. Okay. Section 7C, alternative dispute resolution. I describe this as if a dispute cannot be worked out between buyer and seller alone, you agree to go to mediation rather than to court and share the cost of mediation equally. If mediation does not resolve the issue, both parties agree to binding arbitration before a professional arbitrator that you both agree on. The decision made by the arbiter is final and binding. However, either party has the option to notify the other in writing within 30 days after mediation to opt out of binding arbitration and to continue with court action or other remedies. It's kind of interesting, and the contract writes it this way. They say right up front, if mediation doesn't work, both parties agree to go to arbitration. And then immediately after that, it says, well, that's not really true. Because if you, it says right here, notwithstanding the foregoing, either party may opt out of binding arbitration within 30 days after the conclusion of the mediation conference by notice to the other, and in such event, either party shall have the right to resort to court action. So they're clearly trying to play down the ability to go sue in court rather than go to binding arbitration. I find it interesting that it's written that way, rather than just saying if mediation doesn't work, you can decide to go to court or go to arbitration. But instead it says that you agree up front to go to arbitration. Almost a little contradictory. But that is the best way I came up with to try to describe it as concisely as possible. And then let's throw in some more confusion to ADR. There are some exclusions from alternative dispute resolution, which is abbreviated here as ADR. And these lines say basically that this paragraph describes a few exceptions to the requirement of binding arbitration. One of those is if either party files an action in Arizona Small Claims Court, which currently limits damages to $3,500. The other exceptions listed here include foreclosure, unlawful detainer, which is the legal term for eviction, and probate court jurisdiction. If either party files a legal notice of pending action in the future, lis pendens, that does not excuse them from the obligation to mediate or arbitrate. How many new agents who are new this year in real estate can tell me what lis pendens is? Jump in there.
Isn't that lawsuit waiting? Like there's going to be a lawsuit?
Pretty much, yeah. What it means is you can file a legal notice and record it in public record that you are going to sue over this, that, and the other, but you have not sued yet. A lis pendens can have a very negative effect on somebody that's trying to sell their house. If there's a lis pendens on the property and the seller's trying to sell, or this seller, for instance, tries to cancel and resell to another buyer after a lis pendens is recorded against the property, that's going to be a problem. That's going to be found in the title search, and that's going to be a cloud on the title that's going to be an issue. So in other words,
Mark, does a lis pendens is a lis pendens also pertinent to like a judicial foreclosure situation where they'll file that and court is letting them know that there's a judicial foreclosure pending?
possibly. I'm not, that sounds probable. A judicial foreclosure probably would qualify as a lis pendens, but it might be just filed as a judicial foreclosure, because I don't know that they, well, judicial foreclosures are very rare in Arizona, especially in residential real estate. And so I don't know if I know the answer to that, Dennis, sorry.
Okay.
And by the way, when we're on these topics in this remedy section, we also need to be very careful about giving legal advice to our clients. If you are doubtful at all about what you're about to say, don't say it. You might want to suggest if they're asking questions beyond what you believe is your role as their realtor, then you might want to say, you know, I just don't know the answer to that. I suggest you talk to a real estate attorney if you want more information on that. That makes sense? And now this sentence here, or my explanation, the other exceptions listed here include foreclosure, unlawful detainer eviction, and probate court jurisdiction. I'm not 100% clear on how those might apply, but I believe that it means that if a foreclosure happens, if there's a foreclosure going on the property at the time a dispute arises between a buyer and a seller, then that foreclosure is a complete exception to this, and it just can proceed as, you know, in its natural course, and it excludes them from having to go to binding arbitration. Same thing with an unlawful detainer or eviction, or if it's a probate sale, a probate court issue on there might force buyer and seller not to go to binding arbitration. And that's what this clause is about. It's only about the exclusions from going to binding arbitration. These exclusions do not apply to mediation. Mediation is an absolute. Mediation is the first option where you and the buyer and seller agree to go before a mediator, which is more often than not a retired judge. I've been to mediations before, and on 2 different occasions, and both times that's who the person was. It was a retired judge. And the goal of mediation, keep in mind, versus binding arbitration is that judge or mediator does not make a decision. He tries to get the buyer and seller to come to an agreement. Have I successfully confused everybody yet?
No, it's good. The other thing I would add, Mark, is that the same goes for agent versus agent problems. And we have our associations that we belong to, and part of your membership in those associations is that you agree to go into a mediation type of conversation with another agent if there's a commission dispute, let's say, and that you would actually go in front of a board called professional standards. And that's the way it's handled in Arizona. It's probably similar in Colorado and Washington. It's the same idea as you're basically saying, okay, I'm willing to go talk in front of a jury of my peers, so to speak, and basically hash it out with another agent. And then that governing body makes a decision. So it's kind of similar in that regard.
And that governing body is other realtors, right, Jeff?
Yes, yes.
Have you ever been on a mediation board like that, Jeff?
I have not, but I've sat in where I've seen we've had to, as a broker, we've had to go in and actually defend our agent.
Okay, so
And,
you've
you
been
know,
to them. Okay.
Yeah, a good agent would bring their broker into that. It's, most likely you'll go your whole career and you won't be called into one of those. That's probably a good chance. But, if it does happen, you just do the right thing. And your broker also will be there. If they're a good broker, they'll be there to support you.
Thanks for that, Jeff.
Yeah.
Okay, down here, section 7E, attorney fees and costs. Pretty simple. In fact, you could just read it verbatim and it's easy to understand. But I would say if a dispute continues beyond mitigation, you agree that the prevailing party will also be awarded attorney's fees and costs. So keep in mind, the first thing the buyer and seller in a dispute they agree to do is a mediation. And that mediation, they split the cost of that equally. Everybody agrees to that up front. But everything after that, loser pays attorney's fees and costs to the prevailing party. Okay, additional terms and conditions. This is obviously, I think it's page 8 or is it page 9 of the contract? Either one, it's the big blank space on the contract. This is simply where you write in other clauses, things that aren't part of the boilerplate or the contract or have a place to fill in. And I just describe it as, and in fact, I'm not describing, when you see the italics here, these are not words you say to the buyer. These are the words I'm saying to you. And I just make sure that any clause you do write in here in this section is very specific and absolutely clear with no ambiguity, pardon me. My mouth isn't working this morning. Reference any part of the contract that the clause may affect. And it's okay to be a bit wordy. I think many agents write their own clauses in an effort to be as brief as possible, and then thus they leave a lot of ambiguity. For instance, notice in here, I just wrote a sample in here of a particular clause that might be in there. In the event that buyer is unable to obtain loan approval 3 days prior to close of escrow, as described in section 2B, notice I reference specifically the section of the contract that this clause is addressing. All parties agree that the close of escrow date on line 24, again, referencing the specific line, shall be November 3rd, 2020. What I'm saying here is if this might be written if we're a little nervous that the lender might come through in time to get the loan docs to title 3 days prior as described in section 2B. We're all agreeing to extend the close of escrow date for a week. I think that's about a week in this example. So be very specific. Make sure there's no question as to what you mean, because this could have been written in the event that buyer is unable to obtain loan approval, period. Everyone agrees to extend the closing date 1 week. That's just full of holes, absolutely full of holes. We need to be more specific than that. Any questions on that? Awesome. We just knocked out an entire page of the contract. Okay, 8B, risk of loss. I explain that this way. If the property is damaged in any way, oh, Dennis is trying to get back in. Welcome
Can I
back.
add something? Hey, Mark, could I add something on the last page?
Sure.
Page 8, where you put your additional terms and conditions. Again, in every state, you're going to have a page like that. Be very cautious as to writing things in there without really thinking about it. Like Mark said, oftentimes the contract boilerplate takes care of a lot of the things that people put in additional terms and conditions. If you read through the entire contract, it's about as detailed as you can get. So don't put something in there that's already covered somewhere else in the contract. And I would advise, as you start writing contracts, have somebody else look at your contract, especially if you put additional terms and conditions. That extra set of eyeballs is really critical.
Excellent point, Jeff. I cannot tell you how many contracts I see on a regular basis that have things written in on this page in the additional terms that are simply already covered, just like Jeff said. That tells me a lot of agents don't really understand the contract, like the rest of us do now, right?
That's right.
Okay, 8B, risk of loss. If the property is damaged in any way before close of escrow, it is the seller's responsibility to repair the damage at their expense. If the cost of the repair exceeds 10% of the purchase price, either party can cancel the contract. So obvious, if the house burns to the ground before close of escrow, 100% the seller's responsibility, and the buyer almost certainly is going to cancel because that's going to clearly be more than 10% of the purchase price. But if any other damage occurs and the seller is agreeable to repairing it, the buyer can't cancel unless it exceeds 10% of the purchase price. So keep that in mind. I don't know about you, Jeff, but I have never, ever had this happen. I've never had a property canceled because of damage that happened prior to close of escrow. Have you?
No, I haven't, but I've had a house of mine burned down.
Well, I've got a neighbor just around the corner over here. The house burned almost to the ground just a few months ago.
Yeah, I mean, I was a KB home sales rep, and we were about 90% of the way done with their house. And a couple kids went in the night before and burned the house down. And I had to call the buyer and explain that to him. It was kind of a hard conversation.
I'll bet. Okay, line 394, really self-explanatory. Both buyer and seller give the broker permission to tell the public that this contract is this. Does anybody have an idea exactly what that is? Can they describe to me in a circumstance as to how that looks in real life?
MLS.
MLS, you put right in the MLS, there's a place to put in, for instance, multiple offers received. You can tell any prospective buyer or their agent that we already have an offer. They're giving you permission to say it exists and also to promote it as a sale that you've completed. Braden, who's not here today, who I'm mentoring, he just got his first contract at $545,000 accepted. And some of you might have seen his post on Facebook that, hey, under contract, I've got this home under contract. He got that permission right there in the contract by both buyer and seller to make that public. Okay, obviously Arizona law, ridiculously self-explanatory. The laws of Arizona apply here. Other states' laws do not. Okay, this whole page, this latter part is pretty self-explanatory. Time is of the essence. The parties acknowledge that time is of the essence in performing their obligations described herein. I state that as this. It is very important that both buyer and seller do everything within the time frames stated in the contract. And then you can elaborate off of that if you want to, but it's just, I'm trying to impress on my buyer in this case that these timelines, time dates, and expiration dates are very, very important. We must meet them. Compensation. Both buyer and seller acknowledge that the brokers are being paid for their service per a separate written agreement. Both buyer and seller agree to abide by any commission agreement they previously entered into. There is also a disclosure that commissions are not set by any board or association. commissions are only negotiated between broker and client. So they're saying it's clear that everybody's acknowledging that the listing and selling agent are getting paid, that the amount of that compensation is stated somewhere else in writing, not in this contract, and never, ever, ever under any circumstance should there be any reference to commission written into this contract. Never do it. And if you see it in a contract, you need to get it countered out or have it rewritten if it's a contract submitted to you. It does not belong there. And this part that's in capital letters is just the disclosure, like I said here, making sure that the buyer and seller both understand that these fees are net set. They're not set by the government. They're not set by the Board of Realtors or any group of people that get together. It's called price fixing. That's what they're trying to make sure we're all aware of. Okay, we just did that.
Can I say something on that, Mark?
Please do.
I thank you so much for letting me chime in. This is good stuff. Okay, so always remember that you're going to hear numbers out there, and we can speak about commissions because we're all within the same brokerage. We're allowed to do that. So let's say people you're going after a 6% commission. Just remember that you can get whatever the market warrants. There's times where I've gotten 7% commissions, 8% commissions. There's nothing that's holding you back from charging more commission. Always know that. And and as we get through and we train more and more, we'll give you scripts and dialogue to help you with those conversations. But just because somebody else is discounting their commission, that doesn't mean that's the going rate. You never want to use that term, going rate. You get your commission, what you think you're worth, and that's a whole nother class. But your commission is based on the value that you provide. And so it's always about value. It's always about how much value you're showing to the client. I have no problems getting the commission I usually want most of the time after I do a whole presentation sharing my value. So I don't want to, that's another road, but I just want you to know that you don't put it in there in this contract. That's a whole separate document, but get as much commission as you believe you are worth.
Excellent, Jeff, excellent. And you said avoid the going rate. Yeah, that's a problematic phrase. I like to say that I believe my commission is competitive. That's the word I use. If I've got a seller, I literally had an appointment this morning before this meeting with some sellers that were trying to beat us up on commission. And I remember I used those words. I said, but we're competitive. We're charging a very competitive commission to what other agents are charging out there. And I don't think you disagree with me, Jeff, on that that's okay to say? Good. Thank you.
Totally okay, yeah.
Yeah, not the going rate. Okay, copies and counterparts. Just right off the bat, who can tell me what a counterpart signature is? New agents only. Nobody knows what counterpart signatures means. Awesome, something I'm actually gonna teach.
The other parties?
The other part, yeah, it pertains to party A and party B, buyer and seller. But counterpart signatures is a very specific term that identifies a very specific thing that happens with the documents. I was just curious if they taught that in real estate school a lot. I don't think they did, but
becomes an executed contract.
What's that?
It becomes an executed contract.
It does. It does, but specifically how it gets from unexecuted to executed is where we come into the idea of counterpart signatures. I'll explain it right here. Copies and counterparts. Electronic copies of this contract shall be treated as the original contract. This is just I'm explaining this paragraph right here, 8G. Electronic copies of this contract shall be treated as the original contract. Counterpart signed copies are also binding with the exception of the lead-based paint disclosure, which must contain the signature of buyer and seller on one copy. That's the only document the contract says must be signed by each party on the same piece of paper or on the same electronic automatically generated what turns out to be a PDF. Those are not counterpart signatures. All periods of time expressed in days are calendar days, not business days, weekdays, or I'm sorry, not business days, period. Weekdays and holidays are included. I emphasize that to my buyer and my seller when we're talking about the days of the contract. These are not business days. We work on weekends and holidays. And here's my, I skipped over this, I apologize. Counterpart signatures, here's the definition. Counterpart signatures are exact copies of the same document, one copy signed by the buyer and one copy signed only by the seller. That's what counterpart signatures are. You will rarely do counterpart signatures in the paperwork that we do, but it can happen. If you could do an addendum and have that exact same addendum, copy A and copy B, copy A signed by the buyer, copy B signed by the seller, and as long as they say the exact same thing, they are binding. That is counterpart signatures that are binding. I've had escrows in recent past where the escrow company got documents signed in counterpart. You'll see it happen much more in the escrow process than in our contract writing, if I made any sense of that. Is that clear to everyone what a counterpart signature is?
Yeah.
Sorry, I was confused there.
Completely.
That makes sense.
Okay, awesome.
I got one more thing on that page. It's really important. Let's say, for example, Alex goes out this weekend and sells her first house. And yeah, get down with your bad self. So let's say she's writing on an offer. She has a buyer. She writes an offer on Saturday. They accept it on Sunday night. So the contract is accepted Sunday night. When is day one of the inspection period start? Based on lines 409 and 410. When does day one start? Does it start on Sunday or does it start on Monday? Anyone?
Sunday.
Bueller?
Be Sunday.
It would be Monday. The day of the event meaning acceptance, that's when you've accepted the contract, is the event. So day one is the next day. Okay, very important because you have a lot of events in a real estate contract. You have tons of events. You have the acceptance, you have when the inspection period is over, you have a time that you can get back to the buyer on their repair requests. There's a bunch of events in the life of a escrow, and always remember day one is always the next day after that event.
Thank you very much, Jeff. In fact, I kind of glossed over that, and I should have explained it a little better. Another way I think might be a good way to describe it is the first day doesn't count, the last day does count. So if that contract is executed on Sunday, Sunday doesn't count. So day one is the next day. But at the end of that, and for example, the inspection period here, Monday is day one, and you count 10 days forward to day 10. The 10th day does count. That is the day that the BINSR must be submitted to the seller. So the first day doesn't count, last day does count. Hope that helps. Okay.
Alex has a good question on the feed.
Oh, go ahead. Let me.
Well, I think I just saw at line 409, it said that business days and weekends and holidays are included in that 10-day inspection period. Am I correct on that?
That is correct.
Okay. All right.
Let's see. Yeah, calendar days, another way to say it, calendar days. And that includes, and literally Christmas is included.
Okay.
Easter is included. So keep that in mind.
Okay.
Sorry, I don't know of a way to counter or to handle watching the chat as well. So if you guys can watch it for me, if something comes up that needs to be answered, please let me know. Okay, 8J, entire agreement. Simply put, there are no other written or verbal agreements that the parties are relying on. Only what is in writing in this contract and addendums counts. Also, if either party misses an initial on any page, that does not invalidate the contract. Very common occurrence. Initials get missed all the time, especially the ones that on a couple pages where they're not at the bottom, but they're up in the body of the page. And Jeff schooled me on that a few weeks back, because I said, absolutely, it's not a valid contract if the initials are missed, but that is not the case. So you can just go back later and fill in the initials. Subsequent offers, 8K. You acknowledge that the seller, we're talking to the buyer here, you acknowledge that the seller has the right to accept any offer as long as they have not agreed to yours in writing. So it's important that we move quickly as possible to get the contract signed by the seller. So make sure they understand. I had a buyer just this week that literally had a very difficult time understanding the fact that he wasn't under contract to purchase the property because he'd made a full price offer. He's asking me to schedule the inspections right away because I want to move as quickly as possible. And I'm saying, I can't. We don't have an offer. We don't have a contract accepted. Well, it's full price. And yes, it was full price, but price is not the only term of the contract. There are dozens of terms that every contract can have that the seller has to agree to in writing. Where was I? Okay, cancellation, self-explanatory. If any party who wishes to exercise the right of cancellation as allowed herein may cancel this contract by delivering notice stating the reason for the cancellation to the other party or to the escrow party. Cancellation shall become effective immediately upon delivery of the cancellation notice. And that's obviously if they're canceling under a term of the contract where they actually have the ability to do that. Okay, notice 8M. I describe this paragraph by saying all notices must be in writing and delivered by one of the methods listed here. As your agent, I will make sure all notices are delivered properly. Let them know. There's not a single provision in this contract that says the listing agent or the selling agent will do this or must do that. It's all the buyer and the seller will do or must do or shall do these things. Remind your buyers and sellers both occasionally that, hey, I'm going to be walking you through this. I'm going to make sure all these things happen on your behalf. And note that regular USPS mail is not an approved method for delivery of notices. That's interesting. I hadn't really thought of that, but you cannot send a notice via regular mail, and it will not be valid if you do that. And let's see, I highlighted this for a reason, and address to buyer as indicated in section 8Q, to seller as indicated in section 9A, and to the escrow company in 3A. And we're going to talk a little more in depth on that because that's on, most of that's on the last page of the contract. There's very specific ways that you're required or specific methods that you're required to send the notice to the other agent. I'll get to that in a minute. I like to, if I've got a good rapport with my buyers or sellers as well, I'll just say, this is the paragraph that says if something goes wrong, you won't sue me. Can't use that with all buyers or sellers, but I explain this paragraph this way. Myself and the seller's broker are only licensed and qualified to advise you on and control certain aspects of the real estate sale and purchase process. This disclosure lists a number of aspects of the process that we are not qualified to advise you on or are out of our control. It is important that you read and understand this paragraph before signing the contract. That's the best way I could come up with to explain it in plain English. That this is just to keep us out of court. That's the whole purpose of that paragraph right there. Us as the agents. Okay, the terms of acceptance on 8.0. This is where we state a specific date and time that the seller must accept this offer. Your offer expires at that time if the seller has not accepted. You may withdraw this offer at any time prior to the seller accepting it. This topic comes up a lot, and everybody wants to know, what is the proper amount of time that you should give the seller to respond to an offer? And I have a lot of agents still to this day say, oh, I'd give them as short as possible, give them no more than 24 hours. We want to make sure that we force them to respond. I have a completely different opinion of that. I don't like that idea. I believe a seller is going to respond in the time that they're comfortable responding, regardless of whether or not you give them a super short timeline there. There you go, Mike. He's waving his hands. I got some agreement there. I usually give 48 hours minimum, maybe more. What's that, Mike?
That was my neighbor, actually. Sorry.
Oh, you're neighbor. I thought you were just saying, good job, Mark. So I like to give 48 hours, unless, and maybe more, if it's been stated in the MLS that it's an out-of-town seller or something, or there's some reason, or institutional seller, like a probate situation or something like that, where it may take the seller more time, then I allot that time. Jeff, I'd like to get your thoughts on my opinion of that. See if yours is similar or different.
Well, I think every situation's different. I like to ask the listing agent, what would be the best scenario for them. I'm always trying to ask questions to get in better and better graces with the listing agent, because there's one thing you'll learn about this business: you'll sell more real estate if you have good relationships with the cross agent. So I think every single deal is different. Like if you think the property is going to hit the market on the weekend and there's going to be a flurry of activity, and let's say they put it on the market on a Thursday, and you get out there with your buyer on the Thursday, I would probably try to get that under contract prior to the weekend. So I may ask the listing agent, would you be okay if I put this terms of acceptance a little bit faster, because we got a really good offer here. I want to get it tied up. I want to make your seller happy. I just think it depends. And I do know other times when you give them more time, sellers appreciate that. There's so many variables, depending on the market you're in and the actual deal you're in. So you have to kind of think through that on every offer.
Excellent. Thanks, Jeff. Excellent.
Yeah. And if I can get your guys' opinion on this, because I'm actually dealing with this today, unless there's time at the end, I can talk about it at the end.
There'll probably be time at the end. We're getting really close. Why don't we do that, Mike?
I'll wait up.
Okay. Lines 8P, section 8P. This is just a reminder that you should read all 10 pages of this contract along with all addendums and attachments before signing. The listing that I took this morning, that I had issues with by the way, we did get the commission we asked for when they balked at it. That guy read every single word of the listing agreement while I was sitting there in front of him this morning. So it does happen. Okay, the final page, signature page of the contract. This is not addressed to the buyers, what I'm going to talk about here. This is addressed to us as real estate agents, as what we should be concerned about on this page. Make sure you fill out your agent info completely, and make sure you use the specific phone number and email address that you want the other agent and escrow officer to use to communicate with you. Remember a couple paragraphs back that said, if anybody can remember, it says notices must be given as addressed to the buyer as indicated in section 8Q, and to the seller as indicated in section 9A, and to the escrow company indicated in section 3A. So whatever methods of contact are listed in those sections is where those notices need to go to. It must go to this. In this case, the other agent must send all notices via email to that email address. I use 3 or 4 different email addresses, and I may inadvertently communicate with another agent with a return address showing a different email than this. If that agent replies to that, I'm gonna get it, but technically it wasn't a valid notice because it wasn't sent to that email address. And the preferred phone number, that's the phone number that you're expected to be answering and being able to get voice messages from and that sort of thing. So make sure these are the ones you want. And don't forget to check this box. This is a very easily missed box to check on the signing page, where you identify who you're representing. And then where the buyer signs, by signing, the buyer is not only agreeing to the terms of the contract, they're also acknowledging that they received a copy of the contract and the buyer attachment at the time they signed it. It's always best for the buyer to sign exactly as their names are printed on line 1. I think technically it's not a valid contract if they don't, possibly, but maybe not. But keep it consistent throughout the contract. Who can tell me what the buyer attachment is? Referenced right here, besides Jeff. Interesting. Anybody?
Is it the agency contract?
Well, this is for Kelly and Mike. This probably or may not apply, but the very first page of the purchase contract is called the buyer attachment. And I don't have an example up here to pop up, but Jeff's got it right there. It's a checklist for the buyer. It's disclosures about what the buyer should consider when they're reading and reviewing and signing this. Tells them the things that they must do or they should do as they progress through this sale. That's the buyer attachment. So they're acknowledging that they got it at the time they signed this. And keep in mind, this is actually pretty important. In fact, Holly in a recent broker meeting talked about this a couple months ago anyway, that the buyer is acknowledging that they got a copy of this contract literally the moment they finished signing it. And that is true. When it's electronically signed, you're covered there. They did get a copy, or at least it was available to them electronically. And again, I do a lot more paper contracts than the average agent because I work with an average age group in the mid 70s for more than half of our transactions. But back in the old days, our contracts, they were only one page, of course, but there was carbon paper. They were carbonized paper, literally. And then when they finished signing, you ripped off a copy and handed it to the agent. Then you'd rip off another copy and you'd submit that with your with the contract. That was the contract you submitted to the escrow company. So technically, if you sign on a piece of regular paper and that buyer does not get a copy of it at that moment, instead you say, I'll scan it and email it to you later, that's not consistent with what the buyer agreed to. And Holly's point was that get one of those scanning apps that you can put on your phone and scan every page of the contract and email it to the buyer after scanning on your phone before you leave the signing, if you're doing it on paper. Those of you that have done some deals, how many of you actually done a face-to-face paper signing of a contract? Okay, Gene has. It's becoming more and more rare, obviously. Okay, this section of the contract, this is the seller acceptance portion, and this is where the other agent's information goes. When you do it on transaction desk, this autofills. This stuff autofills in there. And the thing is, it may not be accurate. Well, I wrote a bunch of stuff here. Let me read it. This will usually autofill if you import the listing from transaction desk. If line 62 autofills the agent's phone number and or email address, I recommend you delete both and let the other agent add it. If you're handwriting, just leave this section blank for the seller's agent to complete. Remember that section 8M of the contract requires that you send all notices to email address listed on line 462. There's a possibility that the email address that auto it autofills from transaction desk or any other program for that matter may not be the one that agent wants to use for notices. And that's what that email address is, for notices. So I always leave it blank. And if I see an obvious mistake up here in that agent's information, I'll wipe that out as well, let them fill it in. But I try to keep it like the stuff that's really easy to confirm, that their MLS code and ID and Office MLS code, leave that in there for their convenience so they don't have to fill it in themselves. And I talk about the fact that many agents use multiple email addresses to communicate, so don't just hit reply to a recent email from the other agent when sending a time-sensitive notice, such as the Binzer, for example. Make sure you send it to the email address provided by the other agent and contact and ask for confirmation of receipt. This is a habit that you should absolutely be in. When you send any type of notice that's time sensitive, that there's some sort of deadline on in the contract, you really need to reach out to that agent. In the email itself, the very first line, I say, see the attached whatever, please confirm receipt. And if I don't get receipt within a reasonable amount of time, an hour or two, I'll make a phone call or send a text to that agent and say, hey, I just want to confirm that you got that notice. And then this box here, even though it's in the seller agents section, I have no problem checking it off myself, because we know it's very clear at this point who the seller's representing. We know they're not, we know if they're representing both buyer and seller or not. So no issues there, in my opinion. Okay. And this is where the seller signs, of course, and it's just basically the same as the seller's signature section. Obviously, you fill in the obvious things. It's a good idea to have for the seller's agent to put the seller's mailing address in there. Most of the time, it doesn't happen. It's not a big deal. You can just provide. The only place you really need it is the escrow company. They are going to need it because there are things they must send by mail or overnight. So, and this section here is just where the seller checks it off and indicates that they have rejected the offer. It's not really an absolutely necessary thing for the seller to do, but it's good form that if you're working with a seller and your seller rejects an offer, to have them initial that section and send this page and only this page back as confirmation to the buyer's agent that it was rejected. Okay, that's it. And we finished in under an hour. It's 9:58. Sorry, my mouth wasn't working this morning really well. Pretty common for me, but it is what it is. Mike, you want to jump in with that question?
Yeah, unless anyone else had anything pressing.
I just have one quick thing, Mike, and I'll be quiet after that. It's I want everybody to understand something. This is really important. When I was a brand new agent, it was way back in 01. Rich, your baby looks beautiful. You can get really tied up in all the details of this contract, and it'll actually keep you from selling homes. Because what will happen is you'll get so worked up about the process of selling a home that it actually subliminally affects your ability to close people and get excited about selling homes. And that I experienced that firsthand. I became Rookie of the Year at KB Home in 2002. But before I did that, I wasn't selling any homes because I was so worried and worked up about all the minutia about what I had to do if I sold a home. I was afraid I wouldn't know what to do. So I want you just to know something. When you sell a house here, we got plenty of resources. We've got your back. You know, I've got your back. Mark's got your back. We got brokers. We'll help you the whole way. You know, that's what your support staff is for. So you just go out there and sell and we'll help you. And the biggest thing that people want to know, remember, is they want to know, do they like you? Number one, are you likable? They want to know if you can negotiate on their behalf, and they want to know if you can market their property. Commission's not always the number one thing. Remember that. But if you go into it thinking that, then that's a limited thought on your behalf. Think about those three things about bringing value, and then commission always works out. If you highlight your contract, the last thing I'll say, I know this contract like the back of my hand, And when you're in front of a lister or a buyer and you're talking about the contract and you know it in your head, that's value. They start sitting back and going, wow, this person actually knows what they're talking about. You will sell a lot more homes. So this is a sales technique.